In what some call a landmark judgment, the Supreme Court has upheld the amendment, the 103rd Amendment to the Indian Constitution, which paves the way for the Union government to allow or carve out 10% EWS reservation. Now, this reservation has seen a lot of debate and discussion, and today at South First, we are joined by Dr. G. Mohan Gopal, who very passionately argued in the Supreme Court against this quota. Thank you so much, Professor, for joining us. And with us today on the show is also Mr. Vasu Gandikota, the founder of South First. And we hope to try to give you an insight into the debate that happened in the Supreme Court and the way forward now that the Supreme Court has decided to go ahead to give its sanction to this amendment made to the Constitution. First of all, Professor, in your defense, you actually, in the Supreme Court, said that allowing EWS reservation goes against the basic principles of the Indian Constitution. Your stance has been vehemently against EWS quota. My question to you is, does it truly benefit the poorest of the poor of this country?
I think that's a good place to start. Mr. Vasu indicated to me when we spoke yesterday, I think a very important point, that there seems to be a lot of confusion about what EWS is all about and the lack of clarity. In a simple way, what is it about? And that confusion does not come from any inherent complexity of the idea, or indeed of any inability of people to comprehend the idea. It comes from deliberate duplicity. Right from the beginning, there was duplicity in presenting it for what it was. So first of all, we say that the government says that they are implementing the mandate in Article 46 of the Constitution. Now, what does Article 46 of the Constitution say? Its title is Promotion of Educational and Economic Interests of Scheduled Castes, Scheduled Tribes, and Other Weaker Sections. Okay, promotion of educational and economic interests of Scheduled Castes, Scheduled Tribes, and other weaker sections. Okay, that's the title of Article 46, which is part of the Directive Principles of State Policy, Part 4 of the Constitution. It says, the state shall promote with special care the educational and economic interests of weaker sections of the people, and in particular of the scheduled castes and the scheduled tribes, and shall protect them from social injustice and all forms of exploitation. So we have one fine day a bill introduced, rushed through Parliament in 1 week, and becomes law within 1 week of its introduction with virtually no debate. And the statement of objects and reason says that this bill is being introduced under this provision of the Constitution. That's what it says. I'm not attributing anything to it. The statement of objects and reason says that we are implementing Article 46 by enacting the 103rd Amendment to the Constitution to provide reservation for economically weaker sections. Now, if you read this, you will naturally think that the scheduled castes and scheduled tribes are part of the economically weaker sections. So naturally, most people assume, especially those who are from scheduled castes, scheduled tribes, and backward classes, that this scheme will benefit the scheduled castes, scheduled tribes, and other weaker sections. And they understand from the political speech behind it that this provision, 103rd Amendment, Articles 15.6 and 16.6, will also benefit the poor amongst the upper castes. They assumed that no one is excluded from it. Now, if you look at Article 15.6, so this is where the duplicity begins. Now, where is the duplicity? If you look at Article 15.6 or 16.6, let's take Article 16.6. Article 16.6, which was introduced by the 103rd Amendment, this is EWS, reads as follows. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts, and 15 says for special provisions which will apply to education in favor of any economically weaker sections of citizens. So far, so good. There's no confusion about it. Economically weaker sections of citizens. Now it says, other than the classes mentioned in clause 4 of 16 or clause 4 of 15, in addition to the existing reservation and subject to a maximum of 10% of the posts in each category. Now, if you're not a lawyer, it's very convoluted to know who are the classes mentioned in 16.4 and 15.4. So you suddenly think that there's some class that is excluded here, but it's not clear that it's SCBC or SCST. If it was a political intention of all the parties that supported it, Congress, BJP, left, to provide exclusively reservation for so-called economically weaker sections of upper castes, why did they not write that into the Constitution in a straightforward way? Why didn't this 16.6 and 56 simply say, nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any economically weaker sections of upper castes only, right? That was neither constitutionally nor politically feasible. It would not have been easy to pretend that this is some kind of generic provision to that leads you to ask me, will it benefit the poor of the country? It was never intended to benefit the poor of the country. Parliament decided to say this in a most obtuse and convoluted manner in order to hide something. Now, what was it that they were hiding? They were hiding the truth. What is the truth? The truth is this has nothing to do with poverty. Now, who are we dealing with in this economically weaker sections of citizens who benefit from EWS? We are dealing with, admittedly, a group of people that are socially and educationally, groups of people that are socially and educationally forward classes. So Article 15 and 16 are about representation of certain communities that historically had no representation, which resulted in the south and in the west of the country in movements, popular movements before independence, asking for representation of those who had no representation in public employment or in education. So the issue we are dealing with here is representation. Now, what does this EWS do? It basically says we are going to it's first of all resisting the idea of a representative state. It is blocking the idea of a representative state. It is blocking the transformation of an oligarchy to a representative state by providing unrepresented communities who may be castes, who may be other communities, who may be religions. Article 16.4 provides a fundamental right to those groups to get representation in the judiciary and the executive. And the only purpose of EWS is to stop the transformation from an oligarchic state to a representative state. So the whole EWS scheme is to prevent increased representation of lower castes and minorities in the executive and the judiciary by taking away 10% and reserving it for the overrepresented oligarchy and making it representation free in public employment. So what this does is it has created a representation proof.
I have two questions.
Yes.
One is, why do you think the political parties have sort of endorsed the EWS amendment itself, and now the Supreme Court judgment? Barring the DMK, to the best of my knowledge, I have not seen any strong protest from any political party. Point number one. And if at all we are consider income as a criteria for determining whether someone falls under EWS or not, what is the justification for this 8 lakhs per annum figure? Because for all poverty elevation schemes, there is no hard data to arrive at a specific figure, but it's somewhere in the range of, say, per annum. So how did they arrive at this 8 lakh per annum figure?
Article 46, as I read out, you clearly says that the beneficiaries of EWS shall be victims of social justice and injustice. And and exploitation. So these are that should be part of the eligibility criteria, that you have become economically weak because of social injustice and exploitation. That's not there. Economic criteria are different from financial criteria. Economic criteria are multidimensional. Instead, you've taken the narrowest financial criteria: temporary financial weakness, lack of income at a particular point of time, lack of assets, either real property. Basically, real property, assets, and income are the only two criteria. So you want to increase the number of people from overrepresented communities that get EWS, and you want to block out from public employment and education those who are unrepresented. That's the real game going on here in a very simple way. That's what it is. Behind all this convoluted language, there is a battle to maintain the oligarchy and prevent representation in public employment and education to those communities and groups that currently do not have representation, regardless of their economic condition, whether they're poor or not. The principle in 16.4 put in there by Dr. Ambedkar, unique to our constitution, little bit taken by the South African constitution, but not in any other constitution that I've come across, is the very central principle as a foundation of democracy, that India shall have a representative state in which, in public employment, judiciary and executive, separately in the legislature, all classes of citizens shall be adequately represented. That's the principle we are battling here. Pew Research says that 94% of Indians, of all Indians, are living on less than roughly 25,000 rupees a month for a family of four. That means you're covering through this more than 96%, perhaps 98% of the population, only from social and educationally forward classes. So the purpose of this, in a very simple way, is to prevent the transformation of public employment and education in India from being oligarchic to being democratic. That's it.
Professor, to put it in a different language, are we right in plain and simple words that this is a sort of a reservation meant for the upper caste?
This is reservation meant to stop the transformation of public employment and education in India from being under the control of smaller oligarchies to being representative of all classes of excluded classes that are marginalized. It is a program meant to stop the democratic transformation of India. Reservation is only a tool for building a representative democratic state. We are not interested in reservation. No backward class or no scheduled caste, scheduled tribe are interested in reservation. We are interested in representation in a democratic state. Reservation was a tool for achieving a democratic state. That tool, if we get a better tool, more effective tool, we'll throw away reservation and use that more effective tool, because our struggle is for a representative state. Let me be very clear. We all consider reservation as a dangerous idea, which has to be carefully limited, which is why Dr. Ambedkar himself said reservation can eat up equality, should not be allowed to eat up equality, can be used only for the purpose of creating a representative state, not for any other purpose. So we want to keep reservation as a restrictive tool only for the purpose of ensuring that the state is adequately representative of all classes of people. Tomorrow, Mr. Vasu, if a situation arises where the so-called upper caste of this country do not have any representation in the Indian state, like Muslims today, or like scheduled castes and scheduled tribes today, and some backward classes today, if they come to that condition, then we will fight for their representation also.
Eliminating caste-based reservation. And what would that mean? Because like you pointed out, Indian society is heavily influenced by caste, and we cannot just undo centuries of oppression or centuries of lived experiences of whole communities.
Right. So first of all, let's be clear that reservation for backward classes, scheduled castes and scheduled tribes is not caste-based reservation, is not caste-based reservation. the Supreme Court has said a caste can be a class, but only casteist people will see a class as a caste. Okay. Now, what does this mean? It means any caste or community, any group that meets 15 criteria specified by the National Commission for Backward Classes, the essence of which is that these are groups where the men, the women, and the children engage in stigmatized manual labor for survival. And they have no representation. The criteria are social, educational, economic, and political, including representation. So any group that complies with these criteria are entitled to be called a backward class, not a caste, and then entitled to get reservation as a backward class. Now, who does this include? This includes, as I said earlier, not only groups from various castes, of all castes, not just varnas, and those who are outcasts and therefore have no caste. You know, people who you called outcasts, today you refer to them as castes. They are not castes, they're just independent communities. But they also includes, for example, transgenders, which the Supreme Court included in the socially and educationally as a socially and educationally backward class in a Supreme Court judgment. It includes orphans included by the National Commission for Backward Classes as a backward class, because transgender and orphans are also without representation and without voice and marginalized because they can't speak for themselves. They have no space to speak for themselves. So first point is, you know, let's not buy this false propaganda that SCBC, similarly scheduled caste, any group that meets certain criteria that have been subjected to untouchability, extreme untouchability, it becomes a scheduled caste. That word scheduled caste was introduced by the British before independence. In my view, it should be called scheduled community. Caste. The first time you're listing, you know, caste as the eligible criteria, right? As the eligibility criteria, because you see, caste is the unit. From within those castes, you're picking people who meet the financial criteria. Whereas for socially and educationally backward class, you start with a set of criteria about the group, and then you identify the group. That's why non-castes can be members of backward classes, because you don't have to be a caste to be a member of the social and educationally backward class. But you have to be a caste to be part of the EWS. So that's the first thing. It's caste-based reservation. It's very simple in my view. At one level, there's a lot of things, including the criteria for EWS, that we have to question as being not consistent with with Article 46 and not consistent with the concept of economically weaker sections. We'll try that in court. I have very little chance we'll succeed, but we'll make the arguments. But ultimately, where we go from here is starting in 2024, so that no party and no MP who does not commit to removing counter-democratic reservations from the Constitution will be, we should get the support of those who are not represented, of unrepresented communities, because we want representation, right? So that it may not happen in 2024, but the campaign must begin, and we must ensure that our democratic constitution is rid of this counter-democratic, anti-democratic idea of reservation for the oligarchy. This is oligarchic reservation, right? So that's the way we have to go. And I think we have to protect democratic reservation. We have to fight oligarchic reservation and remove it, but protect.
The point you just made
Yes.
makes me bring you back to Mr. Vasu's question on why political
Yes.
parties largely have not opposed it. From what you say, political decision or democratic elections are perhaps the response to take on or to counter this.
Right. No, the answer is quite simple. I mean, it should tell you who's controlling those parties. If backward classes and scheduled castes and scheduled tribes were controlling those parties, do you think they would agree to this kind of reservation that takes away, that earmarks 10% for the oligarchy and prevents democratic transformation and stops against representation? So it doesn't tell us that there is democratic support for this oligarchic reservation, or there is democratic sentiment against representation. There cannot be. It simply tells us that real power in the parties, except DMK, All India Muslim League, and Mr. Owaisi's party, I think they're the only three, to my knowledge, that actually opposed this amendment. The actual power in these parties is in the hands of the oligarchy communities firmly. And so this will also mean that we need to struggle for a democratic transformation internally within these parties. Because we are 90% of the people of this country. Why should we be pushed around by this oligarchy? Right. So I think this judgment and these actions of these parties will make it easier for us to strengthen, intensify, and take forward our struggle, which is not for reservation. It is for democratic representation and building a representative state, without which no country in the world has moved forward, without a representative state. No, I think, first of all, we have to understand the nature of the decision closely. Frankly, when I started, I expected a 5-0 endorsement by the Supreme Court. But we ended up with a 3-2 split. And the Chief Justice of India struck down an amendment of the Constitution. That's not a small thing. So it's not a kind of unanimous view of the Supreme Court. Yes, the majority, the decision of the majority will prevail, but we have to look at it qualitatively. And today we must take into account very seriously that the Chief Justice of India struck down this amendment as violating the basic structure of the Constitution. And that should influence our view of the Constitution, regardless of the respect we have for the majority. So that's one part. The second part is that there is no doubt that this judgment of the Supreme Court is a powerful argument in favor of greater diversity and greater representativeness of the entire judiciary, including the Supreme Court. It's a powerful argument. It's a the counterfactual is speculative, but what would the Supreme Court have decided if it was more diverse and speculative? Why are Supreme Courts in other countries, like in the United States, insisting on diversity? Why did, when one Justice Stephen Breyer, white male, decided to retire, why did they insist that an African-American woman must replace him? They already had 3 women. They already had 1 African-American male, but they realized that they did not have an African-American woman. And African-Americans are, are a minority. A relatively not large proportion of the population. So, but they still insisted that an African-American woman must be one of the 9 judges of the US Supreme Court. And they did that, right? So we know from all over the world that judiciaries believe that their merit and quality depends on their diversity and their representative character. Today, we do not have the diversity and representativeness that we require in the Supreme Court, in the high courts, and we must have that if we are to move forward on the path of democratic transformation.
But my question is also a counter argument by those who support EWS quota has been that, otherwise non-dominant representation quota has been around for 75 years and nothing substantial has come out of it, or you're continuing every few years, every decade, you keep expanding reservation. Is it really working is the question that is posed often. What is your response to it?
I think for 2 responses. One is the idea of a representative government is deontological. It's not utilitarian. It's an end in itself. If you want to call yourself a democracy, your state must be representative. That's why the American Supreme Court wants an African-American woman to be one of the 9 judges of the US Supreme Court, because for them, that's more. Now, does that work? Will it make America's growth better? Will it make it a stronger country? That's not an issue. We're all human beings. We are groups. We must all have a seat at the table. So I think, is it working is not the question. That's our fundamental human right. But leave that aside. Certainly look at Kerala, look at Tamil Nadu, and look at the social indicators, And these are states which have the longest experience to in giving importance to representation. We had the Malayali Memorial, we had the Irava Memorial in the 19th century. Mysore gave representation, and those days it was all openly for representation, non-Brahmin community representation. And those states which had representation have certainly moved far ahead of those states which did not have a representative government, right? But the advantage then was, therefore it works, clearly works. You compare the states where there is no representative government, where there's an oligarchy ruling the state, and those where the oligarchy is a little bit less powerful, and you'll find the difference. But what we need is a social census, social group census. I can't say caste census because only the Savarnas have caste, the rest are outcasts, so we can't call it caste census. But social group census, we must have that, so that that used to happen before the independence. We had data on who is represented. And let me tell you, my greatest concern is not that the large communities, like I don't want to name them, but the large communities get representation. My concern is that the small communities must get representation. Religious minorities must get representation. Like they're concerned about African American women getting representation. Until this lady came and very recently, do you know that every single one, at one point of time recently, every single one of the 9 judges of the US Supreme Court was a member of a minority? There was not a single white Anglo-Saxon Protestant judge in the Supreme Court, right? Imagine an Indian Supreme Court with no dominant caste Hindus, right? That's how it was. Because they know that a country where the minorities, the weakest, feel safe and the weakest have opportunity, that's a strong country, right? Whereas, where the strong are strong and the weak are weak, the countries fall apart. So therefore, I think we must ensure that we must have a social census. We must identify social groups. They're organic. They're constantly transforming. They're not created by legislation. Groups are constantly changing. So we must keep track of the social groups and make sure that all groups, especially the stigmatized and the marginalized and the powerless groups, are duly represented at the highest tables of power in society. That's the way we can move forward. Yeah, it's a cancer in the Constitution that has to be removed.
Thank you so much. Thank you so much, Doctor, for joining Southwest. Thank you so much, Mr. Vasu Gandikota, also joining us on the show. This is Anusha, Ravi. Do stay tuned to Southwest.